In this part 37, we will continue our discussion regarding trial before a court of session, and the section with which we are dealing is section 233 of the Criminal Procedure Code, which deals with evidence on behalf of the defense. Now, there are various defenses that can be raised on the part of an accused person. The first defense is that of total denial. The second defense is that of alibi, and the third defense that can be raised on the part of an accused person, that he is not liable because his case falls under any one of the exceptions right from section 76 up to 106 of the Indian Penal Code dealing with general defenses, which are general exceptions. So now he can have evidence on his behalf. Now, during the course of evidence on behalf of the defense, all provisions with which you are dealt as far as evidence on behalf of the prosecution, namely the manner in which evidence is to be recorded, the manner of examination in chief, cross-examination and re-examination, all the provisions are applicable as far as evidence on behalf of the defense is concerned. With this now, can accused person be a competent defense witness? Can he himself put himself into the witness box is the question, and the answer to it is found as far as section 315 of the Criminal Procedure Code is concerned, which says accused person to be competent witness, and it says, subclause 1 says, any person accused of an offence before a criminal court shall be a competent witness for the defense and may give evidence on oath in disproof of the charge made against him or any person charged together with him at the same trial, provided that he shall not be called as a witness except on his own request in writing. Secondly, his failure to give evidence shall not be made the subject of any comment by any one of the parties or the court, or give rise to any presumption against himself or any person charged together with him at the same trial. Subclause 2 says, any person against whom proceedings are instituted in a criminal court under section 98 or section 107 or section 108 or section 109 or section 110 or chapter 9 or under part capital B, capital C, capital D or chapter 10 may offer himself as a witness in such proceedings, provided that in proceedings under section 108, section 109 or section 110, the failure of such person to give evidence shall not be made the subject of any comment by any one of the parties or the court, or give rise to any presumption against him or any other person proceeded against together with him at same inquiry. Now, it also, when we start dealing with the procedure as far as the trial is concerned, it say you have to read section 316, which says no influence to be used to induce disclosure, and section 316 says except as provided in section 306 and 307, no influence by means of any promise or threat or otherwise shall be used to an accused person to induce him to disclose or withhold any matter within his knowledge. Now, these right from section 306 and 307 deal with tender of pardon, with which we shall be dealing during course of our lectures. But this is the point that has to be taken into consideration. With this now, evidence during the course, as we are dealing with evidence on behalf of the defense, the court also, so if there is evidence on behalf of the prosecution, there is evidence on behalf of the defense, the court has got also power to summon material witness or examine person present, and that is made very clear. This is what is known as court witness as far as section 311 of the Criminal Procedure Code is concerned, which says any court may at any stage of any inquiry, trial or other proceeding under this code summon any person as a witness or examine any person in attendance, though not summoned as a witness, or recall and re-examine any person already examined, and the court shall summon and examine or recall and re-examine any such person if his evidence appears to be essential to the just decision of the case. With this now, the court has got power to order person to give specimen signature or handwriting, as made very clear as far as section 311A of the Criminal Procedure Code is concerned, which says, if a magistrate of the first class is satisfied that for the purposes of any investigation or proceeding under this code, it is expedient to direct any person, including an accused person, to give specimen signature or handwriting, he may make an order to that effect, and in that case the person to whom the order relates shall be produced or shall attend at the time and place specified in such order, and shall give a specimen signature or handwriting, provided that no order shall be made under this section unless the person has at some time been arrested in connection with such investigation or proceedings. So that is as far as section 311 is concerned. With this now, the evidence on behalf of the we have dealt with evidence on behalf of the prosecution and evidence on behalf of the defense. Now, during the course of time, as I mean, whichever may be the trial, we will come across, as we have dealt with, the court has got power, commission for the examination of witnesses. Similarly, there can be deposition of medical witnesses. For that we have, as far as the deposition of medical witnesses is concerned, we have to, along with this, it is necessary for us to refer to section 291, which says the deposition of a civil surgeon or other medical witness taken and attested by magistrate in presence of the accused or taken on a commission under this chapter may be given in evidence in any inquiry, trial or other proceeding under this code, although the deponent is not called as a witness. Subclause 2 says, the court may, if it thinks fit, and shall, on the application of the prosecution or the accused, summon and examine any such deponent as to the subject matter of his deposition. Whereas section 291A says, identification, a report of magistrate. Any document purporting to be a report of identification under the hand of an executive magistrate in respect of a person or property may be used as evidence in any inquiry, trial or other proceeding under this code, although such magistrate is not called as a witness, provided that where such report contains a statement of any suspect or witness to which the provisions of section 21, section 32, section 33, section 155 or section 157 as the case may be of the Indian Evidence Act apply, such statement shall not be used under this subsection except in accordance with the provision of those sections. The court may, if it thinks fit, and shall, on the application of the prosecution or of the accused, summon and examine such magistrate as to subject matter of the said report. Now, in case where evidence is required to be given by officer of the mint, section 292 says, any document purporting to be a report under the hand of any such officer of any mint or any note printing press or of any security printing press, including the officer of the controller of stamps and stationery or of any forensic department or division of forensic science laboratory or any government examiner of a question documents, or any state examiner or question documents, as the case may be, as the central government may by notification specify in this behalf, upon any matter or thing duly submitted to him for examination and report in the course of any proceeding under this code, may be used as evidence in any inquiry, trial or other proceeding under this code, although such officer is not called as a witness. The court may, if it thinks fit, summon and examine any such officer as the subject matter of the report, provided that no such officer shall be summoned to produce any record on which the report is based. Similarly, Section 293 deals with report of certain government scientific experts. Section 294, no formal proof of certain documents is required, whereas Section 295 deals with affidavits in proof of conduct of public servant, and Section 296 deals with evidence of formal character on affidavits, and 297 authorities before whom affidavits may be shown is dealt. So these are the section. This is as far as the recording of the evidence is concerned. With this, now, if we come back to the come back to the section, namely evidence after evidence on behalf of the prosecution is over and evidence on behalf of the defense is over, and the court then now Section 234, as far as trial before a court of session comes into picture, it says, when the examination of the witnesses, if any, for the defense is complete, the prosecutor, now this is the time for the prosecutor that he shall sum up his case, and the accused or his pleader shall be entitled to reply, provided that where any point of law is raised by accused or his pleader, the prosecution may, with the permission of the judge, make his submission and with regard to such point of law. Now, after the court has heard the prosecution and the defense, now this is the time where the court has to pass a judgment. And in order to know the provisions regarding judgment, it is necessary for us to deal right from Section 353 up to Section 365 of the Criminal Procedure Code, a chapter which tells everything in detail regarding judgment, with which we shall be dealing during course of time. Now, Section 235 says, after hearing arguments and points of law, if any, the judge shall give a judgment in a case. So, judge has to deliver a judgment for which I mean, as I told you, we have to refer to right from Section 353 up to Section 365 of the Criminal Procedure Code. Now, if the accused is convicted, the judge shall, unless he proceeds in accordance with the provisions of Section 360, hear the accused on the question of sentence and then pass sentence on him according to law. So there can be, this judgment may be that of conviction, or this judgment may be that of an acquittal. If he is acquitted, as we have already learned, trial always results into either conviction or acquittal, or if there is an order of acquittal, the trial ends. But if the court has found the guilt of the accused person beyond reasonable doubt, then the court is guided as far as Section 361 of the Criminal Procedure Code is concerned. This has got reference to judgment, as I have told you earlier, right from Section 353 up to Section 365. And what court is expected to do? Court, as per Section 361, court is expected to give special reasons. It says special reasons to be recorded in certain cases. And it says, where in a case the court could have dealt with an accused person under section 360 or provisions of the Probation of Officers Act of 1958, a youthful offender under the Children Act 1960, or any other law for the timing in force for the treatment, training, rehabilitation of youthful offenders, but has not done so, he shall record in its judgment the special reasons for having done so. So this is required to be done by the judge as far as section 361 is concerned. And then the time for us to take into consideration the next part,